is Hui. My name is Karen. My name is Xuan. My name is Hui.
Misrepresentation is when the plaintiff claims that he or she relied on inaccurate and material information which causes the plaintiff to enter into the contract. Both English and Malaysian law generally impose no liability for silence or non-disclosure during negotiations. English law tends to take a more commercial approach, and a good example is the absence of a duty of disclosure in negotiations. Doctrine of caveat emptor, which means let the buyer beware, is applied to the purchase of real estate, but may also apply to sales of other goods. Under the principle of caveat emptor, the buyer could not recover damages from the seller for defects on the property that render the property unfit for ordinary purpose. The only exception was if the seller actively concealed latent defects or otherwise made material misrepresentation amounting to fraud. In Smith and Hughes, it was held that passive acquiescence in self-deception does not avoid a contract, and in Pig and Gurney, it was held that the mere non-disclosure of material facts, however morally considerable, did not create a cause of action. Using the same rationale, the House of Lords held in Bell and Lever Brothers that the unilateral mistake as the result of innocent concealment did not justify the contract being rescinded. Whereas Malaysian position, it is illustrated in Section 17, subsection B of the Contracts Act 1950. It explained that mere silence as to facts is likely to affect the willingness of a person to enter into a contract is not fraud, unless the circumstances of the case are such that it is the duty of the person keeping silence to speak, or unless his silence in itself equivalent to speech. Although Malaysian law generally imposes no duty of disclosure, there are two possible circumstances where non-disclosure amount to fraud. First, the exception is where there is a duty of the person keeping silence to speak. Second exception is where there must be an active concealment of a fact. In Malaysia, the maxim of caveat emptor is still a good law until today. This has been illustrated in the case Hadland after John and another and Audrey Elaine Gomez. The court held that the general principle governing the purchase of landed properties is that the principle of caveat emptor is applicable to the purchase of a completed tourism property. It is difficult for the court to find an assumption of responsibility requiring disclosure in construction contracts, which are often concluded following a lengthy tender process, including written questions and answers which are subsequently incorporated into the contract. If an issue has been left out of the contract documents, it will not be raised in the future. The parties have discussed it before deciding to sign the contract. In practice, the contractor can then decide based on his experience and professional judgment whether the risk of such information providing in occurring needs to be priced. The reason for a disclosure duty is to prevent failure to disclose relevant information which the other party does not know exists. It is difficult to see this happening in a commercial context where the information is relevant, as an exclusion clause will provide sufficient protection. While silence does not amount to misrepresentation, partial disclosure of the facts could amount to misrepresentation and provide an effective remedy. The duties of mutual trust and cooperation which now exist in modern forms of contract, for example, engineering and construction contract, could give an indication as to how such duties could operate in practice. However, a lack of clarity as to the extent of the obligation may lead to excessive disclosure of any matter to avoid allegations of breach of the disclosure obligation. Despite the obvious benefits of this approach, anyone considering an enhanced duty of disclosure should be aware of the effect on contract management and the need to price for the cost of such obligations. There is clearly a balance to be had, and the engineering construction contract seems to have achieved that by limiting disclosure to specific issues. However, it is less clear whether such a balance will be achieved if duties of cooperation and mutual trust are regarded as creating a broad duty of disclosure.
Since disclosure of information in Malaysia is not provided by any statute and highly dependent on the inspection of the purchaser and goodwill of the vendor, aspects such as voluntary duty to disclose, matters that need to be disclosed, time for disclosure, effect, and penalty for non-disclosure must be clearly provided in the statute. Besides, issues such as the distinction between patent and latent defects, the complexity of disclosure statement, the determination of actual knowledge of the vendor about the defect, the imposition of duty to inspect property must also be given attention in drafting the vendor disclosure law. As Section 1 of the Partnership Act 1890 defined that a partnership is the relation which subsists between persons carrying on a business in common with a view of profit, with a business in this context including every trade, occupation, or profession. There has been questioned that in which circumstances joint venture could amount to a partnership and whether there is a pre-contractual duty of disclosure between prospective partners. The term joint venture refers to a relationship between two or more parties carrying business activity. The significance of whether parties' relationship amount to a partnership is that the prospective partners are subject to a pre-contractual duty of disclosure according to the pursuer. If the pursuer could establish that the defendants owe or had breached a pre-contractual duty of disclosure to them, then this could provide the pursuer with a means by which to have the joint venture agreement reduced. In the segment of company ownership disclosure and liabilities in Malaysia, there has provision in the Companies Amendment Act 1985 in respect of two main areas: the disclosure of directors' shareholding and disclosure of substantial shareholders' interests. The source of this new provision follow closely to the Edison Committee 1969. It is more distant than antecedents are found in the UK Companies Act 1967 and the Jenkins Report of 1962. In respect of the director's shareholding, the holding company must maintain a register showing with respect to each director particular of shares, etc. in the company, or in the subsidiary being shares in which the directors have a relevant interest. Section 134 of the Companies Act 1965 states that a company shall keep a register showing with respect to each director of the company, particularly of the shares in the company, debentures of the participatory interest made rights or options of the directors and contract to which the director is a party. The basic purpose of the disclosure duty is to acquaint shareholders with the identity of the individual companies or small groups which might have holdings of share, which might enable them to gain control of the destiny of the company. The provisions also enables the ministry to require any locally incorporated bodies to comply with the disclosure requirement of substantial shareholders. This is an important power because the operation of the disclosure requirements may extend to other bodies corporated set up specifically by the Act of Parliament. Furthermore, by virtue of the Section 69C, the duty to comply with the disclosure requirement extend to all persons, whether resident or non-residents, to non-Malaysian citizens. And it also extends to act done or omitted to be done outside Malaysia. The law seeks to ensure compliance with the new provision are through penalties and court's power. For example, in penalties, if the company fails to comply with the requirement of keeping register of substantial shareholders, it is liable together with every official who is in default to a penalty of 5,000 ringgit. In the case of Victorian decision of West and Comfort, it was held that there was a legal requirement imposed on company to lodge certain notice and returns within 2 months after the occurrence of a certain fact. The power of the courts has been vastly increased in respect of the situation of the defaulting substantial shareholders. As the new law stands, it represents a radical intrusion into the management of the companies, especially in relation to shared ownership. Lastly, the utilization of the legislative technique of disclosure as a means of control of the corporate behavior has gone unchallenged for a very long time. The new disclosure provisions of the Companies Act discussed represent a trend initiated in the UK as well.
Common law principles for insurance law started much of their development in the mid-18th century. During the late 19th century, there was driven support from businessmen to codify many of the commercial area of the common law, such as the Sales of Goods Act 1893, the Partnership Act 1890, and the Marine Insurance Act 1906 that introduced certainty into many areas of the dealing of such men. The short title indicates that this act is specifically for marine insurance. However, it has been held by the House of Lords in Pan Atlantic Insurance Co. Limited and Pine Top Insurance Co. Limited to apply equally to all insureds, where they be marine or non-marine consumers or businesses. One of the key issues with the Marine Insurance Act 1906 is that it favors the insurer in relation to the remedies, as he can avoid a policy for misrepresentation, non-disclosure, or breach of the utmost good faith. There's a doubt that the insurer should have the right to award a policy where there has been a fraudulent misrepresentation or non-disclosure. The House of Lords in Economics and Commercial Union Assurance Co. mitigated the harshness of this remedy to prevent the insurer from awarding his policy obligation where there had been an innocent misrepresentation or non-disclosure. However, this did not address the issues of negligent non-disclosure. Under the current law, a negligently made misrepresentation or non-disclosure will allow the insurance to avoid the policy as if the insured had acted fraudulently. The law of non-disclosure originates from the case of Carter and Boehm, which developed away from this interpretation during the Victorian era to become a heavier duty on the insured, so that he had to disclose all material facts and not make material misrepresentation. Therefore, issue becomes, what is materiality? The answer is contained within Section 20, Subsection 2 and Section 18, Subsection 2 of the Marine Insurance Act 1906 and states, every circumstance is material which would influence the judgment of a prudent insurer fixing the premium or determining whether he will take the risk. Therefore, there are two issues which are materiality and influence to be considered. In relation to the test of materiality, the key issue that of a reasonable or prudent insurer. This is an objective test and therefore does raise issues for the insurer if a fact is not objectively deemed to be material. In relation to influence, it has been interpreted so that a fact would be deemed to have influenced the formulation of an opinion or judgment, so that a reasonable insurer would have acted in a different way. Once this has been proved, the next issue would be inducement. The requirement for the insurer to be induced was introduced in Pan Atlantic and Pine Tops, where it was stated that a particular insurer, in cases of non-disclosure and misrepresentation of a material fact, must have been induced to enter the contract. This could be seen as an equivalent of the but-for test in negligence, in that it introduces the requirement for a causative link to be established, which is, would the insurer have entered into the contract but for the misrepresentation or non-disclosure? This was in part as a result of the common law of contract requirement that there must be an inducement to enter into a contract, for without this there can be no rescission of the contract, and as the Marine Insurance Act 1906 was a codification of the common law, this was logically implied. Perhaps the decision in Pan Atlantic did not overrule the previous cases and establish a new precedent. However, materiality is still based on what effect a fact would have had on the prudent or reasonable underwriter. Two major legislative interventions have had a significant impact on the common law rules on disclosure and representation in insurance contract in the United Kingdom. These are the Consumer Insurance Disclosure and Representation Act 2012, which applies to Consumer Insurance, and the Insurance Act 2015, which applies mainly to business-related insurance policies referred to as non-consumer insurance contracts, although some of its provisions apply to both consumer and non-consumer policies.
The Law Commission has proposed that contract law should be maintained, in that the misrepresentation should induce the insurer into the contract. They have addressed issues under fraudulent and reckless misrepresentations and innocent and negligent misrepresentations. Clearly, there is a gap between innocent and fraudulent misrepresentation. As the law currently stands, the insurer is allowed to avoid a contract where there has been a negligent misrepresentation. Under the strict letter of the law, an insurer will provide the policy and then he will keep the policy payments. He later avoids paying out on the policy for a negligent made non-disclosure by the assured. Therefore, the approach proposed by the Law Commission has been to graduate the remedies for the insurer and the insured. The key issue in this respect is the requirement of some feasibility, in that the test requires an analysis of what the insurer would have done if he had known the true facts, and this to a degree is speculative and subjective, as it would require the court to ask not what a reasonable objective insurer would have done, but rather what the insurer in question would have done had the full facts been known. This is problematic as a particular insurer may act differently, and this test could not deal with every possible eventuality. If an insurer would have not taken the risk due to their policy guidelines, this could leave the court with no evidence about what an appropriate premium may have been, and thus would contribute to uncertainty, as the insurer would not have accepted the claim, and this would leave the insured without any remedy. If a more reasonable insurer test were in place, however, then, under the same circumstance, the insured would have a potential remedy, and the insurer would be held liable, subject to the basis of proportionality. The advantage of the doctrine of proportionality indicates that the greater the negligent misrepresentation, the smaller the amount of compensation the insured will receive. Nevertheless, no matter in what terms this duty is couched, it's difficult to see how the insured could be compensated if the insurer would have not declined the initial proposal based on the insured's subjective view. Therefore, what may be needed is a reference to an objective reasonable insurer, in that if a reasonable insurer would have charged an additional premium, then the proportionality doctrine would intervene to mitigate the otherwise hardship that may otherwise be caused to the insured. The Law Commission has proposed that the business insured should not have a claim refused if there has been an innocent misrepresentation. The burden of proof in this case will again be on the insurer to prove that the insured did not have reasonable grounds for believing what stated was true. In relation to business insurance, the Law Commission made similar recommendations, in that there should be three classes of claims: deliberate or reckless, negligent, and innocent. And they also suggest how a appropriate settlement would work, in that the courts had to ask what the insurer would have done, and had it been aware of the true position. The Law Commission has been mooting a possible option whereby the insurer could terminate the policy after negligent misrepresentation or non-disclosure after a reasonable period of notice. This remedy may be unfair. If the insurer discovered a negligent misrepresentation or non-disclosure, he may take the view that he should terminate the policy. This the insurer could do even if the claim was not related to the negligent issue. It could be way around him having to continue with the policy. Furthermore, it could leave the insured in a position where he may have to disclose that he has had previously insurance policies cancelled. This in turn would increase the difficulty for the insured, as his premiums may be higher or insurance could be refused.
In Malaysian context, the duty of disclosure has been codified in Malaysia in the Financial Services Act 2013 and the Islamic Financial Service Act 2013, which lay down the duty of disclosure for all insurance contracts. Insurer must rely on the insured so that he can decide whether to accept or refuse the risk. Thus, the duty of the insured is that of full disclosure, and strictly speaking, he should disclose things which are material to the risk, even though he may not be asked. Non-disclosure has to be distinguished from misrepresentation, as non-disclosure is really an omission to say or disclose what should be said or disclosed. Therefore, it is important to note that certain cases of non-disclosure may amount to fraud within the meaning of Section 17 of Contract Act 1950. In Markovich and Liverpool Victoria Friendly Society, it was held that the omission to answer a question cannot be regarded as a misstatement of fact unless the obvious inference is that the applicant intended the blank to represent a negative answer. The case for non-disclosure is KSH and North British and Mercantile Insurance. Plaintiff insured against fire for 80,000 ringgit but failed to disclose that there was an unsatisfied judgment against him. It was held that this fact should have been disclosed as it was a material fact. The other case is Leong Kam Wei and American International Assurance, which involves the question of duty of disclosure under the Insurance Act 1963. It was held that the non-disclosure had not influenced defendants in deciding whether to accept the risk, as the insurer would accept the risk anyway. Misrepresentation are divided into two types, which are fraudulent and innocent. Under Contracts Act 1950, Section 18 had defined misrepresentation. However, whether there be fraud or misrepresentation, Section 19 stipulates that the agreement or contract is voidable at the option of the aggrieved party. Therefore, in insurance, whether the misrepresentation is innocent or fraudulent, the insurer has the option to avoid the policy. In the case of National Insurance and Joseph, the misrepresentation related to the question whether the company had been informed of a previous cancellation of a policy of another company, and also information relating to a previous accident. The trial judge held that he had deliberately suppressed and misrepresented these material facts. One of the unfortunate cases where fire policy was involved is Wong Lang Hong and National Employees Mutual General Insurance Association. It was apparently a case of innocent misrepresentation, but the insured nevertheless suffered for it. The plaintiff, Madam Wong, had merely studied Chinese at primary school level, but on the evidence, she had approved of the answers before signing her name in Chinese on the proposal form. The trial judge found that there was misrepresentation and the policy was held to be void. Thus, plaintiff could not recover for the loss by fire. It can be seen that from the above cases decided by Malaysian judges that in declaring the policy void for misrepresentation, reliance has been placed on English decision and no reference has been made to the Contracts Act, which allows a contract to be avoided for misrepresentation or fraud within the meaning of the Act.
As a conclusion, in the cases where positive duty of disclosure exists because of the reason of particular relationship of the parties or the transaction is ubi mene fide, the transactions may be avoidable on the grounds of non-disclosure, although the non-disclosure does not amount to misrepresentation.
Except mere silence or inaction, morally reprehensible it may be, it still constitutes to the misrepresentation.
Previously, mere non-disclosure does not give a right to damages, but now, where it is a duty to disclose, non-disclosure is amount to unequal representation and may result in damages.
The circumstances states that when there is no possible duty of disclosure exists, silence does not amount to fraud. When nothing is done or to be said, there is no misrepresentation.
However, the dropping of a single word or the making of a single gesture in such a case may amount to misrepresentation.
Thanks for watching!